This month could be a pivotal one for the mountain of legal troubles of the disgraced, twice impeached, 4 times indicted, liable for sexual abuse ex-president. Because he happens to be the frontrunner for the Republican nomination for a historically unprecedented 3rd time, it could be a pivotal month for the 2024 election and for our democracy as well. Any day now, we are expected to hear from the D.C. Circuit Court of Appeals on Trump's claim that he cannot be prosecuted for trying to overturn the 2020 election because his efforts took place when he was president of the United States. The so-called immunity claim. No matter what happens there, either Trump or Jack Smith is expected to appeal. We are also waiting on a verdict from New York Judge Arthur Engoron in the blockbuster $370 million civil fraud case brought by the New York Attorney General against Donald Trump, 2 of his sons, and the Trump Organization. And then there is the case that could kick Trump off the ballot that challenged his eligibility based on the 14th Amendment, which bars insurrectionists from running for office. A brief from Trump's legal team is due Monday, just ahead of oral arguments at the Supreme Court on next Thursday. That same day, he will run unopposed in the Nevada Republican caucus. He'll pick up all 26 delegates in that state. The following week, on the 12th and the 13th, there are hearings in the classified documents case. On the 15th, Judge Scott McAfee will hear arguments on a motion to dismiss charges and disqualify DA Fani Willis over allegations that she had an improper personal relationship with the lead prosecutor. Willis has been subpoenaed to testify. That same day, in New York, a hearing on pretrial motions in the hush money case that could determine whether it goes to trial as planned on March 25th. Meanwhile, the GOP primary campaign rolls on. On the 24th, Trump faces off against his sole remaining Republican challenger, Nikki Haley, in her home state. He has, at this moment, a wide lead. At the start of the next month, the question of whether the classified docs case proceeds to trial on May 20th will be front and center at a scheduling conference. All of that brings us to one of the big outstanding questions at the moment. Will the federal election interference case proceed to trial on March 4th as currently scheduled? Officials are bracing for what could be a historic and tense moment for this country. A former president on trial for trying to overturn the will of the voters and inciting an insurrection against the government he led. Less than a mile from the site of that insurrection, the Washington Post reports, U.S. officials are debating how thick of a security blanket they will wrap around the federal courthouse in downtown Washington for former President Donald Trump's trial. Proposed changes for what could be the first criminal trial of a former American president, including ringing all or part of the E. Barrett Prettyman federal courthouse as early as February, with metal fencing, closing or controlling sidewalk access for several blocks, and temporarily closing neighboring streets in the heart of the city. And all that is where we start today with former lead investigator for the January 6th Select Committee, Tim Heaphy. Plus, Andrew Weissman is here. He's a former top official at the Justice Department and co-host of the MSNBC podcast, one of my favorites, Prosecuting Donald Trump. And here with me at the table, MSNBC legal analyst Lisa Rubin. Lisa Rubin, once a producer, always a producer. You helped us put that calendar together.
I did.
Talk us through it.
Alicia, the calendar, I think the most important thing for people to see is how jam-packed it is and how on certain dates in that calendar, February 15th is one that comes to mind. There are going to be multiple consequential things happening on the same day, right? In one courtroom here in New York, a judge is going to determine if the hush money case goes to trial on March 25th. In another courtroom thousands of miles away in Georgia, Fani Willis could potentially take the stand as a witness in a case that she herself has brought. So I think it shows us 2 things. 1, the worlds are converging. Multiple things can happen at once. And 2, how unexpected some of these twists and turns are. I don't think any of us would have or could have predicted 6 months ago that Fani Willis would become a potential witness in her own case due to fundamental questions about the propriety of her bringing it.
Andrew, that schedule, it is dizzying. We're going to get to the questions around the immunity decision a little later in the show. Let's talk about the other big thing that we are waiting for as we sit here, Judge Engoron's verdict. What's the judge taking into consideration in the civil fraud case?
Sure. Well, it would be quite the 1-2 punch given the finding last week of $88 million in total that are owed by the former president to E. Jean Carroll for sexual assault and defamation. If Judge Engoron finds that he is both liable for the causes of action 2 through 7 and the amount of damages. So he is going to be looking principally at the issue of damages. How much needs to be disgorged? How much of ill-gotten gains did Donald Trump reap from the fraud that the judge has already found that he engaged in? And the second issue that I'm keeping an eye out for is whether he's going to be barred for any period of time from doing business in the state of New York. Remember, the Attorney General here in New York is charged with protecting the citizens of New York. And the state has asked for a permanent lifetime bar precluding Donald Trump from engaging in business here. And as Lisa has pointed out, the judge can consider a whole variety of things, including his conduct at the trial, the criminal conviction of the Trump Organization, the new revelations from the court-appointed monitor with respect to loans that appears to have been fraudulent. All of that can go into Judge Engoron's decision. And I suspect maybe part of the reason that he has not met his deadline that he sort of self-imposed of the end of January for that decision. He said he hoped to have a decision by that time, but I suspect it's going to slip a few days, and it may be because of these new revelations from former Judge Barbara Jones about that loan.
Yeah, I think even once we get the verdict, Lisa, we're all going to be wondering still what the delay was. It might be obvious to us at the time, but yes, of course, questions remain. Once this verdict comes down, what then are Trump's options?
Trump's options will be to start his appeal. So you'll remember, before the trial even started, Judge Engoron had found for the Attorney General on the first of her 7 counts. That was that Trump and others of the defendants engaged in a pervasive, long-standing fraud in their financial statements. Trump hasn't been able to appeal that yet because they were waiting for the end of the trial and the remaining 6 counts. From that point forward, Trump can kickstart his appeal, and that means he can ask for a reversal of that ruling with respect to the fact that he engaged in a fraud, any other liability that Judge Engoron finds from his and his co-defendants in terms of intentionally engaging in things like insurance fraud, false financial statements, delivery of those false financial statements to financial institutions that he wanted to lend to him. And then, of course, Alicia, the biggest thing is appealing the relief. Andrew talked about the fact that the Attorney General wants $370 million in disgorgement. That's a fancy way of saying ill-gotten profits she wants to claw back from him. But she also wants a variety of other things, including a lifetime ban on his participation in the real estate industry, banning him forever from becoming an officer or director of a New York corporation. And the Attorney General wants similar things, although not necessarily over the course of their lives, for Don Jr. and Eric, who are steering the ship now, right? They are the functional day-to-day managers of the Trump Organization, at least if their lawyers are to be believed, and I believe they should be. They're running the Trump Organization now, so if they can no longer be officers and directors, query who's supposed to run that organization as a business.
I'm not sure if disgorgement is a fancy way to say ill-gotten profits or if ill-gotten profits is a fancy way to say
Fair
disgorgement.
enough, my friend.
Here's the thing, though. If he wants to appeal, he has to put up a bond, right? So then we get to questions of his liquidity.
That's right. We get up to questions of his liquidity. Now, look, a bond is different than putting up a surety. And usually defendants have one of 2 options. You can either get somebody else to put up the money for you, and you give them essentially a deposit plus some collateral, or you put the whole thing up yourself. In the first of the E. Jean Carroll verdicts, Donald Trump put up $5.6 million by himself. Why? Some people theorize that he couldn't get a company to do it for him. In Fulton County, on the other hand, he did find a company to post a bond for him, and he put down what I believe was 10% of what the DA, I'm sorry, sometimes I get my law enforcement officers mixed up, what the DA was asking him to post. So one of the big questions here is what kind of money will be put up and by whom?
Tim, let's talk a little bit about the 14th Amendment case. Let's make our way through this calendar. That's next week. Trump has deployed a whole host of arguments, saying presidents don't fall under the 14th Amendment, arguing there was no insurrection, only Congress can decide who's disqualified. What are the issues with all of those arguments?
Well, he's got both factual and legal arguments, Alicia, challenging the Colorado case. Factually, the Colorado court found that he engaged in insurrection. That's sort of the triggering factual finding that even gets us into the conversation of whether the 14th Amendment applies as a matter of law. And then assuming he loses that factual dispute, the question then is, does the 14th Amendment, Section Clause 3 of the 14th Amendment apply to the president? Must he be impeached by the Congress before he can be disqualified? These are sort of questions of law as to what the process is for invoking Clause 3 of the 14th Amendment. He will make all of these arguments, the factual and the legal, in front of the Supreme Court next week. Obviously, the lawyers from Colorado that brought the case will have contrasting perspectives, and the Supreme Court will rule. And it'll have ripple effects, not just in Colorado, but on all of the states around the country that are wrestling with this issue of whether the amendment keeps him off the ballot.
Right.